Hello, my name is Yota Negishi, Associate Professor of International Law at Seinan Gakuin University, Fukuoka, Japan. I am highly honored to present a short introduction of my monograph recently published by the Nomos publisher. The title is Conventionality Control of Domestic Law, Constitutionalized International Adjudication, and Internationalized Constitutional Adjudication. I appreciate the editors of the Diritti Comparati, especially Giuseppe Martinico, for inviting me to this precious opportunity. In this video, I would like to introduce the three main points of my monograph. The first is the research problem to be solved by this book. The second is the main research object, namely the doctrine of conventionality control. The third is the most original contribution of this book, that is, the trapezine model of the relationship between international and domestic law. At the outset, let me explain my research problem: structural human rights violations caused by unconventionality of domestic law. Within the so-called Westphalian system, nation-states with sovereignty have primary powers and duties to implement international obligations. According to the principle of subsidiarity in international law, international institutions such as human rights treaty bodies remain complementary to the primary role of states parties. What if, however, human rights violations occur not in single cases, but rather in a systematic way due to the incompatibility of domestic law with human rights treaty standards? That scenario often happens in the state party, in which the executive bodies exert political pressures on the legislative and the judiciary organs. In that case, the unconventionality, the incompatibility of domestic law with human rights treaties, has resulted in repetitive cases in which vast numbers of victims make similar claims like clones on the same factual basis. Then we can ask a question whether human rights treaty bodies should refrain from exerting their authority due to the original meaning of subsidiarity, or should they reconfigure the meaning of subsidiarity to proactively enforce the primary responsibility of states parties? The main topic of this book, the doctrine of conventionality control, indeed emerged to address such systematic violations of human rights. The doctrine was invented by the Inter-American Court of Human Rights in the case concerning the self-amnesty in Chile. In this decision, the Inter-American Court suggested that the judiciary must exercise a sort of conventionality control between the domestic legal provisions applicable to that case and the American Convention on Human Rights. The doctrine of conventionality control has at least two implications to rethink one of the fundamental legal questions, that is, the relationship between international and domestic law. The first implication is what I call constitutionalization of international adjudication. Not only the Inter-American Court, but also European Court of Human Rights started to behave as regional constitutional courts that make authoritative interpretations and conduct judicial review of national acts in terms of their jurisprudence. The doctrine of conventionality control requires human rights courts to focus on the public, even constitutional aim of the regime beyond individual dispute settlements. The second implication is, in contrast, what I call internationalization of constitutional adjudication. Domestic courts have assumed the control of constitutionality, namely the compliance of legislation with national constitutions. In addition, domestic courts also have another important role to review the legality of national acts in light of international obligations. The doctrine of conventionality control converts domestic judges as the primary and authentic guardians of the legal orders established by both national constitutions and human rights treaties. The monograph elaborates a dynamic process of top-down constitutionalization and bottom-up internationalization of education in Europe and Latin America. Specifically, I established a normative model of conventional control of domestic law based on empirical data of comparative human rights practices in both regions. The most original contribution of this book is to propose a new account of the relationship between international and domestic law, that is, pluralist trapezium. This model has the potential to overcome the traditional model of monist pyramid and to illustrate the dynamic practice of conventional control. In the pyramidal model, the summit fixes either international law or national constitution as a supreme norm over the other. However, in the era of internationalization, the pyramidal model is criticized harshly because of its close-mindedness, formalism, and state-centric character. Instead, this monograph presents the trapezium model in light of constitutional pluralism. In this model, the upper base consists of both legal sources, international law and constitutional law. I identify the following three features of trapezium model of conventional control. First, equating international standards with constitutional standards opens up the closed constitutions to the international society. Second, instead of the formal rank of source, the substantive values recognized in both international law and national constitutions are placed on its upper level. Third, above all, the substantive values shaped by an open interaction between international and national legal sources are construed for the sake of persons, not for states. With these short statements, I conclude the introduction of my book. This monograph is open access in the Nomos e-library, so you can download its whole part. Thank you again for this wonderful chance to disseminate my ideas. I hope this work contributes to the world of comparative public law and international law.